The Supreme Court decision in the case of People of the Philippines versus Jose P. RAGUDO, Jr. Insanity in the context of this exempting circumstance is defined in People versus Formigones as being deprived completely of reason or discernment and freedom of the will at the time of committing the crime. In determining whether a defense of insanity may prosper, this court laid down the following three-way test in People versus Paña, thus clarifying the guidelines in Formigones. Considering the foregoing, we clarify the guidelines laid down in Formigones. Under this test, the insanity defense may prosper if 1. The accused was unable to appreciate the nature and quality or the wrongfulness of his or her acts. 2. The inability occurred at the time of the commission of the crime. And 3. It must be as a result of a mental illness or disorder. We now use a three-way test. First, insanity must be present at the time of the commission of the crime. Second, insanity, which is the primary cause of the criminal act, must be medically proven. And third, the effect of the insanity is the inability to appreciate the nature and quality or wrongfulness of the act. As to the kind of evidence to prove insanity, both ordinary and expert witnesses may testify, although the nature of the mental illness of a person may be best identified by experts with specialized knowledge. Thus, insanity, as an exempting circumstance, must be shown medically, unless there are extraordinary circumstances and there is no other evidence available. Our procedural rules allow ordinary witnesses to testify on the mental sanity of a person with whom they are sufficiently acquainted, but reports and evaluation from medical experts have greater evidentiary value in determining an accused mental state. The nature and degree of an accused mental illness can be best identified by medical experts equipped with specialized knowledge to diagnose a person's mental health. The quantum of evidence required to be shown to avail of insanity as an exempting circumstance is clear and convincing evidence. In Paña, this court stated that an accused pleading insanity as a defense cannot competently testify on their state of insanity, as an insane person would naturally have no understanding or recollection of their actions and behavioral patterns. In this case, RAGUDO relies on the reports issued by the NCMH. The initial report issued on October 6, 2015 states that RAGUDO was suffering from psychosis classified as schizophrenia, but nevertheless assessed him as competent to stand trial. Thus, based on the history, mental status examinations, observations, and psychological tests, the patient was found to be suffering from psychosis classified as schizophrenia. This mental disorder is characterized by the presence of delusions, hallucinations, disorganized/irrelevant speech, disorganized/bizarre behavior, and disturbance in affect. Likewise, the patient's impulse control, frustration tolerance, and judgment may be affected. In addition, there is significant impairment in functioning in areas of work, social relations, and self-care. This psychiatric disorder runs a chronic course marked by periods of remissions and exacerbations. At present, the patient is competent to stand the rigors of court trial. Also, the NCMH issued a supplemental report dated February 28, 2018, reiterating its previous finding that RAGUDO suffered from psychosis classified as schizophrenia, and additionally opining that he was insane at the time of the commission of the offense. Thus, based on the history, mental status examinations, observations, and psychological tests, the patient was found to be suffering from psychosis classified as schizophrenia. The nature and characteristics of this mental disorder have been described in the previous report dated October 6, 2015. At present, the patient is competent to stand the rigors of court trial. Prior to the offense, the patient was already exhibiting suspiciousness and impaired sleep for several days. He felt his neighbor was going to kill him and his family. He also felt that people were accusing him of illicit substance use. In his previous statements, he recalled that he was hearing commanding auditory hallucinations. He also narrated, Nakapo pa AKO, Biglang Bumagat, and Pakaramdam KO, Parang may pumasak asayakin, before stabbing the victim with a knife. These symptoms of his mental disorder had caused him to fail to appreciate the nature and quality of his acts or know that his acts were morally and legally wrong at the time of the commission of the crime. It is therefore our opinion that the patient accused was insane at the time of the commission of the offenses. Applying the three-way test in Paña, this court concurs with the conclusion of the courts a quo that it was not sufficiently proven with clear and convincing evidence that accused appellant was insane at the time of the commission of the crime. We affirm the finding of the CA in not adhering to the legal conclusion of the NCMH that RAGUDO was insane at the time of the commission of the offense. To begin, he was examined more than 1 year after the incident, and the finding was thus not based on his mental condition immediately before or during the commission of the crime charged. As found by the RDC, his first examination with the NCMH was on May 13, 2015, or around 1 year and 2 months after the date of the commission of the offense charged, and his last examination was on February 18, 2015, or around 2 years after. Further, as noted by the CA, the opinion of the NCMH was based on RAGUDO's self-serving narration of facts, instead of the testimony or narration of persons with personal knowledge of his appearance and condition at the relevant time. Likewise, as pointed out by the RDC, it was not shown that RAGUDO exhibited any of the above symptoms of his mental illness in the reports immediately before or during the time in question. As found by the CA and RDC, RAGUDO was able to recall several details on the day in question, before and after the time the act alleged occurred, with a peculiar mental block only as to the two extraordinary events of that day, that is, the commission of the crimes.